Should be Erica Ward and Aaron Ward.
Good afternoon, Your Honor. Steve Etherly on behalf of Plaintiff Fixing Housing 401k plan.
Donna Tope on behalf of Aaron Ward and Erica Ward, tenants on the lease.
Okay, where are we on this case, folks?
Your Honor, so the last time we were here, if you need me to get into that, you denied defendant's motion to stay the eviction.
Correct.
And transfer the eviction case to the circuit court. You ordered tenants to produce a full accounting with receipts of money placed into Ms. Tope's escrow account.
Yes.
And of transactions made for repairs and purchase of supplies. You also ordered prorated November rent and rent going forward into district court escrow.
Correct.
We had a hearing on Wednesday on the circuit court action.
Yes.
And as you recall, plaintiff or tenants brought the circuit court action. We filed right away a motion to compel payment of rent. And the circuit court denied our motion for lack of jurisdiction, basically leaving it for you. Your Honor.
They did?
Your Honor, we don't.
Who was that?
Judge outside.
Okay, thank you.
She's retiring.
Pardon?
She's retiring.
I understand that.
Yeah.
But,
She didn't want it.
no,
Your Honor?
no, never say Judge Outside never wanted to deal with it, because that's not it at all. If she felt this court had jurisdiction, that's what she felt.
Exactly. Your Honor, I have the transcript from Wednesday's hearing, if you would like that.
I may need it, but hold on. So that was denied. And so the rent issue is now planted firmly in my lap.
In this court, correct.
Okay.
We can go into the accounting if.
Do I have an accounting?
Yes. I filed it on Monday. With receipts. November 10th. With receipts, and the last page is the final accounting as of that date.
This is the one with the invoices attached.
Yes. You asked for.
Oh, no, I know what I asked for, but. Go ahead. What were you going to say with regard to the accounting? I see this document. Go ahead.
Your Honor, one procedural point. We only received a copy of the accounting because it was e-filed in the circuit court. So I would say service would be improper for the accounting for this court. But I would say to be frank, the accounting is a mess and it's wholly inadequate. I have many questions for Ms. Tope, which I think really highlights the problem here that opposing counsel has inserted herself into this litigation. As the court correctly stated last Friday, there's no legal authority allowing opposing counsel to handle and disperse these funds to contractors and for supplies, especially when these funds were owed to my client under the lease.
Hang on a second, counsel.
Yes.
Ms. Tope,
Yes.
I'm going to ask you a difficult question. I may stop you from answering at some point because I'm not trying to bait you into anything. But these individuals are your clients who, and their attorney.
The hearing begins with appearances entered for both sides in an eviction dispute involving fixing housing and tenants Eric Ward and Aaron Ward. The judge recaps prior rulings, including denial of motion to stay the eviction, orders requiring tenants to provide a full accounting of withheld rent placed into escrow, and instructions to deposit prorated rent moving forward. The plaintiff explains that a related circuit court action declined jurisdiction over rent enforcement, placing responsibility back with this court. The judge confirms that rent issues are now squarely before her and requests clarification regarding the accounting that was filed.
They, at some point, gave you funds, right? Were the funds placed into your IOTA?
No.
Wow,
Can
got a
I,
whole other problem. Because,
Your Honor,
yes,
let me start at the beginning.
no, you're not gonna start at the beginning.
Your
Because,
Honor,
no, you're not gonna start at the beginning.
this.
This Tope. You know what? You say, oh my goodness, one more time, and I'm gonna find you in contempt.
Sir,
I'm stopping you from committing a grievable offense. That's why I told you at the very beginning that I may stop you after my answer, after you gave the answer. Because you have a tendency, when I ask you a yes or no question, to continue to go on and on. And you are going to get yourself in serious trouble. Very serious trouble. I ask specific questions for very specific reasons, because at some point, here's going to be the problem, Ms. Tope, and I'm just going to lay it out this way, and I'm going to try to lay it out without placing any sort of finding or what I'm thinking. If you, as an attorney, are given funds by your client, you must hold those funds in trust. That is typically done through an IOTA account, particularly if you are then dispersing your client's money on their behalf to third parties, to others, or corporate, whatever it is. You then have to have an accounting of that. Moreover, when I start looking at the dates, at some point, these would be required to be reported. Yes, I'll just leave it there. You're going, this intake and disbursement, on the face of it, had to be done in a particular way. Now, there may be something about the transaction that I don't know, but on the face of it, that's what it looks like.
I totally understand what you were saying. Our case filed before the circuit court was filed on July 9th. They had jurisdiction of that breach of lease case. Part of the breach of lease case was that the landlord did not make necessary repairs for the health and safety of all those who were benefited by the lease. We notified them in that case that we would withhold, that they had been requested to make the repairs. They had declined since 2023. We had to make them for the coming winter for the horses and the people that were there. We notified them in August that they paid the rent in July. We notified them in August that we were going to withhold rent and to make the necessary repairs themselves, mitigating, trying to correct the problem. They filed their summary judgment here in this court, which I agree, under a summary judgment, a trust fund would be set up. When they filed on October 20th, this was after months of making repairs.
Ms. Tope, stop.
That's when this court got
Getting
jurisdiction.
things confused.
Pardon?
Getting things confused with what I'm saying and with what you're trying to argue.
Mhm.
I get with reference to any escrow order that the court initiates.
We asked for them.
It's what you did before that, Ms. Tope, that I see as being problematic. You're acting as an attorney, and I'm just going to say this again, and you take in.
Plaintiff's counsel immediately challenges the accounting, calling it inadequate and procedurally improper, and raises serious concerns about opposing counsel handling client funds directly. The judge sharply questions the tenant's attorney about whether client funds were placed into an IOLTA trust account. When the attorney attempts to explain beyond a yes or no answer, the judge cuts her off forcefully, warning that continued talking could lead to contempt. The judge explains that attorneys who receive client funds must hold and disburse them in a legally compliant trust account and must maintain strict accounting, warning that failure to do so can result in serious consequences.
To your possession client funds and then disperse them. So I'm going to put it in the most general sense I can. That has to be done in a particular way with certain accounting that comes with that and certain accounting that must then be reported. What is, well, I'm not going to say it's clear to me because I will say I have very serious concerns as to whether or not that happens or happened. Which, Ms. Toe, may, I'm not saying it will, may subject you to certain liabilities, potentially with the state bar.
That would be because of the circuit court case.
So I'll be honest with you. I'm not the one that you're going to have to explain it to. I mean, but I'm doing my best to say that on the face of what I'm seeing, you may be in jeopardy of some adverse consequences because of what's occurred. That's what I'm saying. What I'm also saying, it's troublesome from the court's perspective because when you refer to you and your clients and certain things that have been done, and this is what happened, and I hate bringing up other cases with reference to present cases, but you keep referring to we in terms of your clients and you acting. Sometimes that is absolutely appropriate, and I don't just, it just is. It's just language. Part of the court's hesitation when you are saying it that way is that, and again, I'm saying this and I'm not making a finding, but if you were operating I'm going to put it in form of a hypothetical, and I hope you can follow it. If your clients were following your advice to place the monies with you and then pay the money out, where that may be in violation of the plain language of the lease, right? They may have a claim, whether they choose to pursue it or not, as to you.
I understand what you're saying.
And so that's a problem for the case proceeding,
I-
because you can't be, you're representing them, but as to the position that they in the business should take, on the face of it, when I look at it, you have a conflict in terms of that.
Okay,
And outside of the fact of the first thing that I said, where you might be in violation, and I'm not saying you are, and I hate even making the accusation, of ethical rules that would apply to attorneys taking clients' money into trust.
I understand.
And again, I will give this blanket statement. I am not saying that, making any accusation. I'm not making any finding. I'm not saying any of that.
The judge expresses deep concern that the attorney may have taken possession of client funds and paid third parties without proper authority or safeguards. She explains that this raises potential ethical issues and possible exposure to state bar scrutiny, though she carefully states she is making no formal findings. The judge emphasizes that she is not the person who ultimately decides professional discipline, but she must address what appears problematic on the face of the record. She also raises concerns about conflict of interest if the attorney advised actions that could violate the lease terms.
I'm not saying even to a great extent my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface.
And your statement that you said was that if I, as their attorney, gave them advice to do what your hypothetical is suggesting, in this situation, the client asked me to handle, because of the lease, the violations of the lease and the threats that the fixing housing made before they filed this action, when we had to file the action in circuit court. Because of the threats, she wanted to have, my client wanted to have everything I's dotted, T's crossed, so that he would not be able to claim that she had not done what tenants are allowed to do, which is, if the landlord does not make necessary repairs, which are the terms of the lease, the tenant is allowed to withhold rent, take on the repairs themselves to make the place safe for their boarders and their horses.
What's the operative word you're using in that whole statement?
Pardon me?
What's the operative word you're using in that whole statement?
The operative word is,
Assuming you're correct on the law, which is a little bit iffy, but that the tenant may.
she asked me to make sure that he wouldn't be able to proceed on his threats. And I agreed to just oversee the,
No, you did more than just oversee.
well,
That's the problem.
and Your Honor, what, in this situation, we're here before you. We requested at our last hearing for you to set up an escrow account, a a trust fund with the court to accept rent going forward.
So I understand that. I know what I did.
Mhm. That's what we're here to move forward with. Are you not going to allow me to represent my clients going forward?
Ma'am, I've not had a motion to force an attorney's withdrawal in this case. If I make that decision, then I certainly can make that decision on my own motion, but I don't have enough before me that I would feel comfortable making that decision. It is a monumental decision if a court directs that to happen. I will say, Ms. Toe, I'm concerned as to whether or not that's where we end up.
That will, excuse me, I didn't hear.
I'm concerned that that's where we may end up.
I share that concern. I would like to know how you would like us to.
Well, I'm okay. So here's what I'm going to do, folks.
As the attorney attempts to justify withholding rent due to alleged repair failures, the judge repeatedly refocuses the issue, stressing that even if tenants believe repairs were necessary, unilaterally withholding rent and dispersing funds elsewhere create a far more serious legal problem. The judge explains that regardless of intentions, rent obligations under the lease appear unconditional, and diverting rent funds without court authorization fundamentally changes the case. She bluntly states that while the situation is messy on both sides, the accounting issues on the tenant side are significantly more troubling.